Pam Bondi panics after Senator Cory Booker exposes her in explosive hearing. Two documents, same department. One said there was no evidence, the other was the evidence. Cory Booker put both of them on the table in front of Pam Bondi and asked her to explain the distance between them. He had spent 47 minutes watching her work through a binder before he did it. 47 minutes watching the pattern. Question, deflection, pivot, attack line, return to question, longer deflection. Long enough to understand not just what the pattern was, but what it was designed to prevent. Long enough to close every escape route before he asked the question that had no exit. He did not come to that table to confront her. He came with documents, and the documents did the work. She couldn't. Not because the question was complicated. Not because the documentary record was ambiguous, or the legal standard was unclear, or the gap between what was produced and what was required was subject to legitimate interpretation. She couldn't because the documents on the table in front of her were from her own department, filed under her tenure, produced under her oversight. And the distance between what those documents showed and what her sworn testimony described was not a matter of analytical framework. It was a matter of fact. The room understood that within the first 60 seconds, and what happened in the 90 seconds after that understanding settled into the space between the witness table and the committee dais is the reason this hearing will be cited in every subsequent account of how the Epstein files were handled, and who handled them, and what they chose to do when the evidence stopped cooperating with the story they were trying to tell. The hearing had its own rhythm before Booker's turn came. The rhythm of a proceeding that has been running long enough that everyone in the room understands the pattern. Question, deflection, attack line from the binder, pivot to the previous administration, return to the question, longer deflection. The Attorney General had been performing that pattern for the better part of an hour. She was good at it. The binder was well prepared. The attack lines were researched. The pivots were smooth enough that a viewer watching without the documentary context might have concluded that the hearing was producing something. It was not producing something. It was producing the appearance of something. The appearance of a cabinet officer engaging with congressional oversight rather than surviving it. The appearance of testimony rather than performance. The appearance of accountability rather than its careful simulation. Booker ended the appearance. He did not announce that he was ending it. He did not signal his approach with elevated volume or visible frustration, or the kind of theatrical preparation that tells a witness what is coming before it arrives. He asked his first question in the same register he had been using for 47 minutes of watching from his seat, measured unhurried. The register of someone who is not performing urgency because the urgency is already in the document. He asked about the investigation closure. In July the previous year, the Department of Justice had issued a memo. The memo stated that prosecutors had reviewed the available evidence and had not found material sufficient to predicate an investigation against uncharged third parties connected to Jeffrey Epstein's trafficking operation. The investigation, the memo said, was closed. Booker had the memo. He also had something else. He had the 86-page prosecution document from the Southern District of New York that had been filed in the DOJ's own record system before the closure memo was issued. The document that laid out the evidentiary case against Epstein's co-conspirators in detail. The document that contained the names. The closure memo said there was insufficient evidence to pursue. The document that was still redacted, still protected from congressional review. At the moment, Pam Bondi was sitting in that chair, describing the release as complete. He put both documents on the table. The closure memo first, then the 86-page SDNY document side by side. One that said there was no evidence, one that was the evidence. Both of them from the same department. Both of them signed in the same institutional chain of command that ran through the witness table where the Attorney General was sitting. The room went still. Not the stillness of surprise, the stillness of people who had been waiting for something specific and were now watching it arrive. The reporters in the gallery who had been covering this hearing with the practiced detachment of people who have seen many hearings and expected this one to produce the usual ratio of heat to light stopped writing. The aides along the walls looked up from their phones. The members of the committee who had been reviewing materials for their own questioning segments put them down because what was on the table was not a political argument. It was not a legal interpretation subject to competing frameworks. It was two documents from the same department produced in the same period, one of which said there was no evidence and one of which was evidence, and the person responsible for both of them was sitting 5 feet away. Booker asked her to reconcile them, not to explain them, not to characterize them, to reconcile them. To account for the specific distance between a closure memo that said there was no evidentiary basis for pursuing uncharged third parties, and an 86-page prosecution document that had been in the department's own files while that determination was being made. Bondi said the department had conducted a thorough review. Booker looked at the 86-page document. He looked at her. He said, "This document was in your department's files when the closure decision was made. It contains the names of individuals the SDNY had identified as potential subjects of prosecution. Was this document considered in the review that produced the closure memo?" She said the department had conducted a thorough review. He asked again, specifically, not generally, was this specific document? He held it up. He named the filing date. He read the document identifier from the header, considered in the review that produced the closure memo. She said, "Our review process was thorough and followed all applicable departmental guidelines." The room absorbed that answer. It is a specific kind of answer that attorneys general give when they cannot give the answer that is being asked for. It is the answer that sounds responsive, thorough, guideline following, procedurally appropriate, while providing precisely zero of the information that the question contained. It does not say yes. It does not say no. It says process and thoroughness and guidelines, and hopes that the question moves on before the room notices that the answer did not address it. Booker did not move on. He said, "I'm going to ask you one more time. Was this document, this specific document with this filing date in your department's record system, reviewed before the closure decision was made?" The silence before Bondi's answer lasted long enough to be its own answer. She said, "I will have to review the specific timeline with my staff and provide a response to the committee in writing." Booker set the document down not dramatically, not with visible frustration, or the kind of physical emphasis that signals theater. He set it down the way someone sets something down when they have confirmed what they needed to confirm and the confirmation is worse than what they expected. He said the closure memo was issued in July. This document was filed in your department's record system 4 months before the closure memo. The question of whether it was reviewed before a determination was made that there was insufficient evidence to proceed is not a timeline question that requires staff consultation. It is a yes or no question about a decision your department made and a document your department had when it made it. She said she would provide a response in writing. He said the survivors of Epstein's trafficking network have been waiting for years for the accountability that document represents. They are not waiting for a written response. They are waiting for an answer to a question that your department's own records make simple. Was the evidence reviewed before the decision was made that there was no evidence? The binder stayed closed for the first time all day. That detail, the binder staying closed in that exchange, is significant because the binder had been the answer to everything else that day. Every question about redaction decisions produced a pivot from the binder. Every request for documentation about the release timeline produced an attack line from the binder. Every attempt by a committee member to hold the hearing to its stated purpose produced a prepared deflection from the binder. The binder had nothing for Booker's question. This is worth examining carefully because the binder had something for every other question. It had pivot material for the questions about redaction standards, redirect to the previous administration's failures. It had attack lines for the questions about release timelines, redirect to the complexity of managing a historically large document archive. It had process language for the questions about specific omissions, redirect to the thoroughness of the departmental review. For every question that had been asked in the previous hour, the binder had contained a tool. Not an answer, but a tool. Something that moved the room's attention from the specific to the general, from the documentary to the procedural, from the evidence to the argument about the evidence. Booker had closed all of those moves before he made his question. He had acknowledged the previous administration's failures, so the pivot to them had nowhere to land. He had named the specific documents, so the redirect to process had no room to obscure the specific. He had framed the question as yes or no, so the redirect to complexity had no complexity to redirect toward, because the question was not a political question. It was not a question about interpretation or policy or the appropriate balance between disclosure and the protection of sensitive investigative methods. It was a documentary question with a documentary answer that was either yes or no. And the yes answer would mean the department had reviewed specific evidentiary material and concluded it was insufficient. The question a defensible position that could be explained and documented and supported with the department's own analytical framework. And the no answer would mean the department had closed an investigation, while evidence relevant to that investigation subjects was sitting in its own files unread. There is no binder line for that. Booker had built the question so precisely, yes or no, this specific document, this specific date, that no redirect could move it. No process language, no complexity argument, no pivot to the previous administration. The escape routes were closed before the question was asked. She could not answer it, and the camera was still running. That inability, the specific visible on-camera inability of the Attorney General of the United States to answer a yes or no question about whether her department had reviewed its own evidence before closing a major investigation, is the thing the hearing produced. Not a political argument, not a partisan exchange, a documentary record of an official who could not account for the distance between what her department said it had done and what the documents showed it had or had not done. Booker was not finished. He moved to the photographs. Congressional investigators had obtained photographs from Epstein's records. Photographs showing Epstein with individuals whose names had been redacted from the DOJ's public release, not photographs of victims. Those were appropriately protected under the legal mandate. Photographs of individuals who appeared in the context of social and professional interactions documented in the investigative record. Individuals whose identities, according to the legal standard governing the release, should have been disclosed rather than protected. Booker put one of the photographs on the table. The binder didn't move. He described what it showed, not the identity of the individual. That was still under seal, pending the committee's determination about the appropriate handling of the materials, but the context. A documented interaction between Epstein and an individual who appeared in multiple cross-reference locations in the investigative file. An individual who, according to the SDNY prosecution document sitting next to the closure memo, had been identified by investigators as a potential subject of inquiry. An individual whose name was redacted in the DOJ's release, while the names of victims were not. He asked Bondi who made the decision to redact that individual's identity. She said redaction decisions were made pursuant to applicable legal standards. He said the applicable legal standard required protection of victim identifying information. This individual is not a victim. This individual appears in the SDNY document as a potential subject of inquiry. The legal standard that governed this release did not require their identity to be protected. Who decided it would be? She said redaction decisions involved multiple review levels. He said, I am not asking about the process. I am asking about the decision. A specific decision about a specific individual that reversed the legal standard in a way that protected a potential subject of inquiry while exposing information about victims. Who made that decision? She opened the binder. The attack line she read was about the previous administration's handling of the Epstein case, about the failures that predated her tenure, about the long history of institutional shortcomings that had allowed the case to reach the point it had reached before she took office. Booker let her finish. Then he said, I am familiar with the failures that preceded your tenure. I have been critical of them publicly and on the record. The question I am asking you is not about those failures. It is about a decision made under your leadership during your tenure, in a release your department described as complete, that protected the identity of a potential subject of inquiry identified in your department's own prosecution documents. That is not the previous administration's decision. It is yours. Who made it? The room was very quiet. That specific quality of quiet. The quiet that follows a question that cannot be answered without consequences, and cannot be ignored without consequences, and has been asked in a room where both of those facts are visible to everyone present. It's something that congressional hearing rooms produce rarely. They produce noise often. They produce performance constantly. They produce the appearance of accountability with reliable regularity. What they produce rarely is the silence that falls when the performance has been stripped away. And what is left is a question, and a person who cannot answer it. That silence is what accountability sounds like when it is working. What Cy Booker had done in that exchange methodically, patiently, without raising his voice, was close every escape route. The pivot to the previous administration was a route he had explicitly blocked by acknowledging and separating the prior failures. The claim of process was a route he had closed by making the question specific rather than general. The binder was a route he had neutralized by making the question documentary rather than political. And the written response offer was a route he was about to close. He said, I will not be accepting a written response on this question. The committee has the documents. The committee has the photographs. The committee has the SDNY prosecution material. The committee has the closure memo. And the committee has the testimony you are providing today under oath, in which you have declined to identify who made the decision to reverse the legal standard in a release your department described as complete. That declaration is itself part of the record, and the record is what will determine what this committee does next. Then he said something that the room had not expected. The hearings that produce lasting accountability rarely produce it through confrontation alone. Confrontation creates a record, but records require interpretation, and interpretation requires context. And context is what gets lost when the coverage of a hearing focuses on the exchange rather than the stakes beneath it. Booker understood this, which is why, before his time expired, he did something that shifted the register of the proceeding from documentary to human. He turned to the survivors who were seated in the gallery, not to perform for them, not to score a political point using their presence. He turned because he had something to say to them directly, and the hearing room was the place to say it. He said, You came here today because you believe this process can produce something. I want you to know that what has happened in this room today, the documents on this table, the questions that did not receive answers, the record that is being made in real time, is not nothing. It is the foundation of what comes next. The closure memo and the prosecution document are now both in the congressional record. The redaction decision and the question of who made it are now in the congressional record. The written response that is being offered instead of an answer is in the congressional record. None of that disappears when this hearing ends. None of it requires her cooperation to persist. He looked back at Bondi. He said, The record you are leaving today will be read by people who have the authority to act on it. I want to make sure that record is complete. So, I'm going to ask you one final time. Was the 86-page SDNY prosecution document reviewed before the closure decision was made? The silence lasted 4 seconds. She said she would provide a response in writing. Booker nodded once. He did not express frustration. He did not perform outrage. He gathered his documents from the table, the closure memo, the 86-page SDNY filing, the photograph, and he stacked them neatly, the way someone stacks materials they intend to use again. And he said, The record is complete. The record is complete. 4 words, the most consequential 4 words spoken in that room all day. Not because they were dramatic. They weren't. Not because they were accusatory or legally freighted or designed to produce a headline. Because they were accurate. because they describe precisely what the exchange had produced: a complete documentary record of a set of questions asked under oath, a set of documents presented into evidence, a set of answers that were not given, and a set of silences that were not as a rhetorical flourish, as a statement of fact about what the hearing had produced. The documents were in the record. The questions were in the record. The answers that were not given were in the record, sitting next to the questions that required them. The written response offer, the substitution of future compliance for present accountability, was in the record. The silence before the final answer was in the record. Pam Bondi's testimony was in the record. All of it. The deflections and the pivots and the binder and the process language and the written response offers and the 47 minutes of watching the pattern before the pattern was broken. All of it was in the record. Now, next to the documents that the pattern had been designed to avoid addressing, next to the SDNY prosecution material and the closure memo and the photograph and the question about who decided that a potential subject of inquiry deserved more protection than the victim's law was written to protect. The hearing continued after Booker's time expired. Other members asked other questions. The binder was consulted. Deflections were produced. The procedural machinery kept turning. But what Booker had built in his time at the witness table did not require the hearing to continue in order to be permanent. It was already in the record, fixed, time-stamped, available to every subsequent proceeding, every future subpoena, every legal process that builds on the foundation of what was documented in that room. She left the hearing. The documents stayed. The 86-page SDNY prosecution document and the closure memo are now in the same congressional archive. The photograph and the unanswered question about who protected the identity it showed are in the archive. The silence before the final answer is in the archive. Two documents from the same department, one saying no evidence, one being the evidence sitting next to each other, permanently available to every subsequent proceeding, every future subpoena, every instrument of accountability that builds on what was documented in that room. The record is complete, not the binder, the record.